This is Performance Test B, State v. Daniel, from the Winter 2015 bar exam. And I'm going to start by giving you an overview of the exam. Okay. What I want you to know about PTs is that they always only have 3 issues. And so your first work is identifying what the 3 issues are. Okay. Your second work is to deal out the library into one and only one of the issues. Then lastly, to locate the format, or to put it all, if there is a format, or to put it all together into the finished product. Okay. So it's kind of like cooking. It's kind of like being a chef. All right. So in this PT Daniel, which from the scores that I'm hearing was definitely the more difficult of the 2 performance tests, right after the assignment memo, there was a motion to suppress evidence. We were representing the criminal defendant, by the way. And what the evidence is a transcript of a 911 call that Peter Daniel made to say that his wife had been killed by his son, and to describe the son and the son's car. Okay. When the police got there, police and ambulance got there, they found that Peter Daniel died with the phone in his hand. So he literally died during the 911 call. He unplugged the phone as he died. His wife was not dead. He thought she was, but she was not quite dead yet. And so the policeman interviewed her using the information from the 911 that the 911 operator gave him, and said, who did this to you? Which son was it? Etc. After the help was, the ambulance was already on the way for her. She'd been hit in the head with a baseball bat too, so she had a brain injury. So she was moving, okay, and the police officer interpreted her responses as affirmations, as assertions, nods and head shakes. All right, but that was disputed by a neurologist who said that brain-injured persons have random body movements, and they may not actually have been in answer to his questions. Okay, so that's the evidence, the 911 call that Peter made, and the police officer's deposition that he observed her saying yes and no to certain questions. All right. So in the motion to suppress, 2 issues are specified as to be excluded: hearsay and confrontation, the 6th Amendment Confrontation Clause. Okay. Then when you go to the library, you see that there are 2 hearsay exceptions listed in the statutes and covered in case law. And those are hearsay excited utterance exception and hearsay public record exception. So from the motion to suppress, you get the initial 2 issues, hearsay and 6th Amendment right to confront witnesses, and then the library breaks it down further and splits the hearsay into 2 hearsay issues so that you wind up with 3 issues: hearsay excited utterance, hearsay public records, and the 6th Amendment Confrontation Clause. And those are the 3 issues in this PT.